Good evening. I think we'll get started even though it's a few minutes early. My name is Bruce Kane, and I'm the Director Designate of the Lane Center here at Stanford. And I want to welcome you all to this event called The Future of Political Reform. This is an event co-sponsored by Stanford, 3 units at Stanford, the Bill Lane Center for the Study of the American West, the Stanford Law School, and the Stanford Political Science Department in conjunction with the FPPC. So we're very pleased to do this partnership. Now, we could have just as easily called this forum, Does Political Reform Have a Future? At this moment in time, there are a lot of problems on the political reform front. Public financing, at least at the national level, is essentially dead. We've seen a proliferation of outside spending groups. The disclosure rules are missing a significant segment of the nonprofit world. And to top things off, President Obama has started a super PAC. So despite the obvious need for repair to the system, what we see, and I see it in DC, is that reform is not possible because the parties are very divided. Divided not just on disclosure reform, but also divided, of course, on voting administration changes like same-day registration and photo ID. So it's an important time to be exploring whether there is common ground, whether we can move forward in a bipartisan way on political reform. So we're very pleased to present this event. Let me say a little something about the format, and then I'm going to introduce the chair of the FPPC. You will see on your seats that there are cards and a pencil. That's because there will be a short quiz after this panel. But also, we want you to put your questions on that. And it's a little complex, but we would like you to pass it to the 2 middle rows. And then we're going to have people collecting the cards and delivering them to Pam, who is going to simultaneously make remarks, moderate, and go through and edit all the questions, which is, for Pam, very easy. Let me introduce then the chair of the FPC and actually the person who inspired this event and brought it to us to partner with. Ann Ravel has been the chair of the FPPC since she was appointed by Governor Brown in 2011. Prior to that, she had experience as the Deputy Assistant Attorney General for Torts and Consumer Litigation in the Justice Department, and then went to work for Santa Clara County, where between 1998 and 2009, she was the county counsel, working on many different topics, including giving advice on the Political Reform Act, which of course is one of the topics that hopefully will come up today. Ann has also served as the governor on the Board of Governors for the State Bar of California, is a member of the Judicial Council of the State of California, and is chair of the Commission of Judicial Nominee Evaluations. And in 2007, was named by the State Bar of California as the Public Attorney of the Year for her contributions to public service. So I give you Ann Ravel.
Hello, everybody. Thank you very much, Bruce, for the kind introduction. And the FPPC is really appreciative of Bill Lane Center and Stanford Law School for their joint co-sponsorship of this event. So we're very happy to be here. On behalf of the FPPC, I want to welcome everybody as well to this discussion about the future of political reform. The California Political Reform Act was enacted after Watergate to assure public trust in government, and then by promulgating certain rules to eliminate corruption in politics. Now, on the eve of the 40th anniversary of the Act, and in this era, as mentioned by Bruce, of unrestricted and often anonymous political contributions and expenditures, it is very important for us to be discussing, one, the failure of the Political Reform Act actually to accomplish its goals. We are very fortunate tonight to have a really great panel that will give their insights as to why campaign finance reform has not engendered public trust, but also what we can do, and as Bruce said, seek common ground to improve the political process. Professor Pam Carlin, who will moderate the discussion, is a leading legal scholar on voting rights and the political process. She is the Kenneth and Harl Montgomery Professor, why are the names always so long? Of Public Interest Law and the co-director of the Supreme Court Litigation Clinic here at Stanford Law School. She is the co-author of casebooks on constitutional law and litigation and on the law of democracy. Professor Carlin is a longtime advocate before the United States Supreme Court, and as one of the many highlights of her career, she has served as a commissioner on the Fair Political Practices Commission. Senator Russ Feingold represented Wisconsin in the United States Senate from 1993 until 2011. Prior to his election to the Senate, he served in the Wisconsin State Senate. He is well known for leading the fight for campaign finance reform and limiting the influence of special interests, and was co-sponsor of the Bipartisan Campaign Reform Act, widely known as the McCain-Feingold Act, which is easily the most significant campaign finance reform legislation in the last 30 years. Since leaving the Senate, Senator Feingold has been the inaugural Mimi and Peter Haas Distinguished Visitor at Stanford, as well as a lecturer in law at Stanford Law School. In 2011, he founded Progressives United, a grassroots political action committee for the declared purpose of standing up to the exploding corporate influence in the political system. Judge Kenneth Starr is the president of Baylor University in Waco, Texas. He was previously the dean of Pepperdine University School of Law. Judge Starr served on the United States Court of Appeals for the District of Columbia Circuit and was the Solicitor General of the United States under President George H.W. Bush. In 1994, he was appointed by a 3-judge panel to be an independent counsel. Judge Starr is not only an administrator and legal scholar, but also an accomplished litigator. While a partner in the Kirkland & Ellis law firm, and I just recently found this out about him, he was one of the lead attorneys in a class action lawsuit that was filed in part by a coalition of liberal and conservative groups, although he represented Mitch McConnell in the case, against the regulations that were created by the McCain-Feingold Act. So we should have a very good discussion tonight.
That's why I'm sitting in the middle. So, well, thank you all so much for coming tonight. Thanks to the FPPC for co-sponsoring the event with all of the different organizations at Stanford that are also sponsoring it. In 1964, the Supreme Court decided the one-person, one-vote case Reynolds against Sims, and Chief Justice Warren, who wrote that opinion, said it was the most important decision of his time on the Supreme Court because it ensured that, and I'm quoting Chief Justice Warren here, henceforth, special interests would no longer play a role in government. Government would be by the people. In 1974, we passed the Federal Election Campaign Act, which was intended to make sure that political scandals like Watergate would never happen again. And so when we look forward on the eve of the 50th anniversary of one of these and the 40th anniversary of the others of these, to the future of political reform, it seems worthwhile to look back to the past of the future of political reform and ask, why have these reforms failed? Why do people have a sense today that politics is, if anything, more prone to control by special interest groups, more vulnerable to money, less likely to produce elections in which voters can elect candidates who represent the public interest? Why has political reform failed?
Professor, I'll kick it off, and it's an honor to be here, and a colleague of yours.
Are you?
Perhaps I should turn on the microphone.
Yeah, we need to turn on, tune in, and whatever else the third thing is.
Professor Carlin, thank you, and Judge, it's good to meet you.
Good to meet you.
You do have to go back to understand this issue, and the short answer is political reform wasn't failing, in my view, as of the day that Citizens United came down at all. It was succeeding. This country went through a very difficult period in the 19th century with the dominance of the robber barons, a term you use lightly here on this campus. But whether it was oil or the railroads in Wisconsin, it was the timbermen and the railroad men that caused a progressive movement in Wisconsin to develop nationally across the Plains states and other parts of the country. A great populist resistance to the dominance of corporate money arose. And a series of important laws were passed. You know many of them. The Sherman Antitrust Act, the origins of the Food and Drug Administration after the jungle, the revelations about Chicago meatpacking, the direct election of senators in the 17th Amendment, something I'm sort of a fan of. And then one other major reform, which is the foundation for this discussion. In 1907, a Republican president, Theodore Roosevelt, signed the Tillman Act. The Tillman Act said that we would not allow corporate electioneering directly from corporate treasuries to dominate our political process. The way that Justice Stevens described it in his dissent in Citizens United was, at bottom, the court's opinion is thus a rejection of the common sense of the American people, who have recognized a need to prevent corporations from undermining self-government since the founding, and who fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. So, of course, Professor, there have been many ups and downs in campaign finance. Money in politics, I assume, was an issue in ancient Athens. I assume it always will be. But for over 100 years, it was the considered judgment of the people of this country through their Congress and through their president that corporations should not be able to use the money that you spend on toothpaste or a gallon of gas for a political campaign. It's never happened to you before 2010. It is only recently. So one of the hard things about this issue is that people naturally want to throw up their hands and say, why hasn't it worked? Well, it was working. We had passed McCain-Feingold, which prohibited soft money, even though people tried to use the so-called 527s, independent expenditures, swift voting, and so on. Actually, the Federal Elections Commission determined that that was not appropriate. And so what happened in 2004 and 2006 and 2008 when McCain-Feingold was in effect? Those elections did improve in this regard. There were not unlimited contributions or secret contributions. There were not unlimited contributions to the parties, and people were discovering the internet. The ability to ask people to give small contributions without any politician calling you up and asking you for money or any quid pro quo. The ability to get a check from a college student for $50, but then ask that same person to come in and lick envelopes or whatever it might be. So I submit that corporate America was frightened by what was happening. And in my view, this decision was engineered to prevent the democracy that was emerging. That is my view of what's happened and why I believe this decision was fundamentally one of the worst decisions, both on the law, which we can talk about later, the problems with why they actually used this vehicle, if you want to talk about that. That's a very serious problem in terms of the court. But from a policy point of view, one of the most devastating things that's ever been done to our democracy, and it is different. It is not the way things have been.
So do you think that, you know, if you take Senator Feingold seriously on this, the Constitution, or at least the Constitution as interpreted by the Supreme Court, prevents political reform? Do you think that's right?
Well, first of all, what are we talking about in reform? Let's go back to Buckley versus Vallejo, because we still live in the shadow of Buckley versus Vallejo. Buckley versus Vallejo addressed statutory amendments. They were very far-reaching. It was the most comprehensive federal effort to address campaign finance and the evils, including evils in the Watergate era and so forth. And the Supreme Court had to address essentially forces of liberty and freedom of speech on the one hand, and forces of equality, leveling the playing field on the other. And that debate continues to this day. And in a very real sense, Citizens United can be viewed, I think, fairly through that prism. Because the forces in favor of liberty, namely freedom of speech, that folks who have something to say should be able to say it. Congress shall make no law. What is it about that Hugo Black would say that you don't understand? No law, abridging the freedom of speech. Now, the senator is absolutely right with respect to the historic, going back to 1907, and rising out of the Teddy Roosevelt administration with respect to campaign contributions by corporations. But it was not the rule historically that corporations could not speak. And in fact, the Supreme Court of the United States, in a very important opinion authored by Justice Brennan, in a very different setting, to be sure, but the specific issue is, do corporations have the right to speak? That had to do with issues in Massachusetts. So a narrow issue, but nonetheless one that gave rise to this broader question. And while there's a footnote reserving broader issues in different contexts, the point was freedom of speech values cause us to argue in favor and conclude in favor of speech. More speech is good, and let it be met by other speech. Now, the forces of equality had succeeded in the Congress of the United States by a very significant margin in limiting expenditures, that campaigns could only spend X, putting a ceiling on expenditures. And the Supreme Court of the United States, by a supermajority, struck those down. And in very strong language, that was the language of liberty and freedom of speech. That conversation has continued, I think, uninterrupted year after year. And the final thing I want to say in this is there is no more ardent defender of freedom of speech, period, on the Supreme Court than Stanford alumnus Tony Kennedy. And after the Supreme Court of the United States decided a case called Austin versus Michigan Chamber of Commerce about 20 years ago, with Justice Kennedy in dissent, Justice Kennedy, I think, became, as it were, even more fervently committed to the principle of liberty and freedom of speech. Briefly stated, Austin versus Michigan Chamber of Commerce involved the Chamber of Commerce in Michigan taking out an ad in a newspaper. Now, newspaper ads are really kind of at the core of freedom of speech, freedom of the press. Think of New York Times versus Sullivan, those of you who are in the law. That was an ad, and that iconic opinion talked about the importance of the ability and a polity in a democratic society for us to be able to speak. What state law provided in Michigan was for the Michigan Chamber of Commerce to take out an ad in a state legislative campaign. And it was a narrative ad. If you go to look it up, if you read the ad, it is not an attack ad. It's very substantive. It's talking about economic issues facing Michigan. And then promoting one particular candidate, one Richard Banda, if memory serves, that he understands these issues, so elect Richard Banda. So it did identify him specifically. That ad was a crime. Now, I heard Justice Kennedy speak extrajudicially after the Supreme Court narrowly upheld that Michigan statute. And it upheld, speaking through the iconic voice of Thurgood Marshall, in a very soaring opinion, talking about the evils of the aggregation of wealth and the need to control aggregation of wealth. This sounds very familiar, doesn't it? Justice Kennedy wrote a vehement dissent, but I also heard him with my own ears in New York give a speech denouncing that case as utterly inimical to the great values of a constitutional democracy. I think the debate that has gone on, including in Citizens United, has been this sort of enduring battle, this conflict of visions between the forces of liberty on the one hand, and then the forces of equality and leveling the playing field on the other. In Citizens United, the forces of liberty and freedom of speech won. But every case seems to be up for grabs.
I mean, so one thing to just let me ask this question. How many of the people in the audience are not lawyers and feel themselves to be a bit baffled at this moment? Okay. So nobody wants to admit to bafflement, but lots of you want to assert to being not lawyers. So one of the things I think to understand about the limits within which we can argue about campaign finance today is that the Supreme Court has come up with a distinction that I think no one thinks is coherent at all. And that is a distinction between contributions to candidates or parties on the one hand and spending money independently on the other. And it's usually referred to as the contribution expenditure distinction because the most discredited distinction, the crack powder distinction, had already been taken by other drugs in the system. And so essentially what the Supreme Court has said is you can limit contributions to candidates because there's a risk of corruption, but you can't limit independent spending. And the result of this is kind of like saying to somebody, you can go to an all-you-can-eat buffet, but you have to take only a teaspoonful of food at a time. It makes people obsessed with food in the way that it has made the system obsessed with money. And it makes a lot of the reforms that people would like to do much harder because the Supreme Court has said the only justification really for restricting speech in the political context is to avoid corruption or the appearance of corruption. And so one of the things I want to ask you, because this reminds me of the first oral argument I ever had at the Supreme Court must have been about your 50th, which was a case that we were doing that involved vote dilution. And when I stood up to argue, Justice Scalia said to me, we were talking about dilution in that context, and he said, how can you talk about dilution without knowing what a full vote would mean? I mean, how would you know if your beer was watered if you don't know what beer is? And so I want to ask you, how would we know if a system was not corrupt? That is, if we're trying to measure corruption, it's presumably a deviation from some ideal. What would that ideal be, and how would you define corruption?
Well, I don't know what the ideal would be. All I know is the people of this country basically knew it when they saw it in the late 19th century. This is a democracy where people sense at some point that things are out of control. They saw the dominance of the oil industry. They saw the dominance of the few. They saw the dominance of the economy, and then they saw the dominance of the political system as well. It's one thing to have monopolies of the economy, but then when that is used through corporate treasuries to also dominate the political process, I think that's when people conclude that you're dealing with corruption. And
so can I just press you a little bit on that, which is there something more corrupt about a corporation spending the money than there is about Sheldon Adelson spending the money, and if so, what makes it more corrupt?
Well, as you indicated, there are two aspects of corruption. One is the literal sense of a quid pro quo. And, you know, I witnessed that in Washington. Floyd Abrams, the great First Amendment lawyer, took my deposition for 9 hours and was kind enough to start it off saying, you know, you have the best record in the whole Senate on the First Amendment. What are you doing with this McCain-Feingold bill? But then he asked me for examples of actual corruption, and I gave them to him. And it's in the record. And a couple of senators never spoke to me again. I mean, where there was an actual conversation on the floor of the Senate about who gave us money the night before. That is something people can recognize as corruption. But there also is a point at which the appearance of corruption becomes apparent to the American people. Now, I think everybody understands that individuals have been able to do this from time immemorial. This is an important question. If you set it up as the judge has, as a question between equality and freedom, and sort of talk about the different players, all natural-born persons, that's one thing. It's a conversation we should have. It is an ongoing conversation. The problem is what this is about is the ability of corporations to take money through commerce with the advantage given to them by the law of limited liability and protection that the rest of us don't have to dominate the political process. That's when I think people start observing an appearance of corruption. They sense that not only is the money affecting their elections, here's the real problem, because one of the things I've had to deal with since the election with Democrats is, we won. This must be a pretty good system. Well, the problem isn't who won. The problem is when both parties are in the tank and have been taking money from Exxon and BP, neither party takes on those corporations. That's corruption. And that is as well as the appearance of corruption, because both parties have been bought off. Or probably, as some of the companies point out, they don't initiate the calls. They once said to me, Feingold, stop calling it legalized bribery, it's legalized extortion. Because the corporate CEOs don't sit at their desk and go, you know, I've got some extra money, I think I'm going to call up Chuck Schumer and give it away. The calls come the other way. So in my view, this is a concept that people do understand as extremely dangerous, and they do sense when basically their political system has been rigged. I think that's what they're feeling today, and I think they regard that as corruption.
Because the corporations' influence on the process after the election?
Because they're able to make it so that neither party will touch them after the election.
That's because they need the money to run the
campaigns.
Because
2 minutes after the election, the head of the Democratic Senate Campaign Committee is, you know, indirectly hoping that a super PAC will help them. Of course, that super PAC is constituted of former staff members of senators who know exactly what they want them to do. So, yes.
So if you can't regulate the speech, is there some other way to regulate this behavior? Or is there just...
Well, my quick answer is transparency. The more we know, at least you can have a conversation about it. I think most of the efforts of reform in the sense of prohibition here, and an area that really does concern me is the criminalization of our politics, and always filing a complaint saying, I think my unworthy opponent did this and did that. And perhaps, this may be wishful thinking, but I doubt it. But when President Obama said, I hereby renounce public funding of public financing of the campaign, you know, there was a lot of criticism. But one of the things that he likewise said in that video, and there was a really powerful video when he's telling, you know, his supporters, I'm turning my back on this. And so this was unprecedented for a presidential candidate. But what he went on to say is 1.5 million of you in the grassroots have now made the old system of campaign finance, I'm paraphrasing, irrelevant. You have responded with, and I think he said $10, $15, and $20, or whatever you could give. You have changed the face of campaign finance in the United States. Maybe that doesn't work in the Senate, maybe it doesn't work in the House, but it does seem to me that the values of transparency, and I would just lift up in terms of my own experience as a citizen as opposed to a lawyer. I lived in Virginia for almost 30 years, and Virginia is a very competitive state. Sometimes it's called a red state, and it's a very competitive state system. There are no campaign contribution limits whatsoever, either on source or quantity, or the amount limits. But there is a very, very, shall I say, robust system of disclosure. By 3 o'clock in the afternoon, you better post that. And they will, in fact, bring criminal charges if you violate the disclosure provisions. Now, having said that, I know, and the senator I know is quite sensitive to this, that, you know, bad things can happen when disclosure is made. And some of the great civil rights cases, NAACP versus Alabama, you don't have to be a lawyer to understand this. The NAACP said, We do not want to disclose our list of supporters. This is the time of the Civil Rights Movement. And the state of Alabama says, no, we need to know who's supporting this organization. The Supreme Court of the United States overwhelmingly held the NAACP does not have to disclose. It's a very important aspect of freedom of speech and freedom of association. I'm very sensitive to that. And I know that there have been very serious conversations about the dangers of transparency. But that being said, there are at least 4 states, including the state of Oregon, likewise. And Oregon has clean politics. I'm not talking about Washington, I'm talking about states. Has clean politics. There will always be issues, but has clean politics. I think there are 2 other states that have the same regime. And I think, drawing from Justice Brandeis, the laboratory of the states, perhaps that's a good system to, let's give that a try. Let's just say, you want to give, you don't have to form some 527, you don't have to form a C4, you don't have to hire a lawyer. We like it when you hire a lawyer, but you don't have to hire a lawyer. Just give, but then the obligation is to disclose. And I think that along with what we have in terms of the radical democratization of President Obama's campaign, and by the way, he raised hundreds of millions of dollars more than Senator McCain in 2008. He raised more money, I think, than Mitt did this last go-round. But if you look at the 2008 numbers, you would think, well, Senator McCain, great war hero, he must have raised a ton of money. He did. But then Senator Obama just completely blew him out of the water by several hundred millions of dollars. Why? Because he used the internet. He had great organization. Obviously, you had a very inspirational, charismatic candidate. So I think we can look to the states, perhaps. The senator may disagree with that.
On this point, let's be absolutely clear that I'm extremely pleased to hear the judge saying that he supports disclosure, because you probably know not everybody does. Yeah. In fact, a whole lot of people who claim that was the answer to the system, who didn't speak as eloquently as Judge Starr, said exactly that the whole time we were doing McCain-Feingold. Mitch McConnell would get up and say, you guys are for government regulation. All we need is sunlight being the best disinfectant. We just need disclosure. So Citizens United was decided. That same court, these people I have this issue with, ruled 8-1 that there should be disclosure. The only dissent was Justice Thomas, who explained in his opinion the same thing that Judge Starr did about the NAACP in some of those cases. But one of the most passionate opinions was by Justice Scalia, saying, of course, if you're going to have corporate contributions, they have to be disclosed. Well, sure enough, we went right in front of the court the next day and immediately introduced, with Ron Wyden and Chuck Schumer and me and Evan Bayh, a disclosure bill. And we took it to the floor, and we got 59 votes. You know, Scott Brown didn't think it was a good idea. All of a sudden, the Republicans are saying, oh, we don't think we should pass a disclosure bill. So they completely flipped on this thing. So we'd have neither a federal disclosure to find out what corruption could be going on, to have the information the judge is talking about, and the valiant effort that's going on in this state is just a couple of votes short of a disclosure law here, which I have been working and supporting, because I think this is a common ground area, at least between the two of us. But there is an iron effort going on to prevent Republicans from joining this effort in Washington. And one Republican has had the courage recently to break those lines, Lisa Murkowski of Alaska, who co-sponsored the Wyden disclosure bill a few days ago. You know, she's the one that lost the primary to a Tea Party guy and had to mount a write-in campaign, as she said, and my name's Murkowski, for a write-in campaign. But this is one of those moments when somebody has said, as Judge Starr has said here, that at a minimum, we should be able to agree that all this has to be out in the open so that we can actually know what's going on, because as we sit here tonight, all over this area, especially in this area, of all the places in the United States, people are being asked to give huge $10 million contributions that are not going to be revealed. And this is unprecedented.
It's one of the things that it seems that you're always chasing the last election in some ways. That is, that that money wants to be in the system. And so if you close it off over here it tends to move in some other direction. And one of the worries that I've seen lots of people point to is as you pinch off money in the places where the Supreme Court will allow you to do it, it flows into more damaging channels. So for example, if you go back to 1974 at the time of Watergate, whatever the corruption was, it was money that was going to candidates and political parties who would ultimately have to put themselves in front of the voters. And when you say you can't give the money to the candidate, then it went into soft money. When you say you can't give the money to the party, then it goes into independent expenditures so that PACs arise. Then when you start regulating the PACs, you get 527s. I assume that if you regulate those, the money goes somewhere else after that. I mean, is it possible to...
I don't think that's what was happening in 2006 and 2008. I think actually we had pinched it off in a way that prevented that from happening, and that's why the court did what it did. The 527 mechanism had been discredited. You couldn't give soft money. I'm sure somebody would have tried to come up with something, but we had the law in a position where it required the Supreme Court to redo the system. So I agree that there is a tendency of money to do that, but I think they were very frustrated with how to do it because of what we'd done, and so they went to the Supreme Court to change it rather than what looked to me like a system that might really be improving.
I think we do have to clarify that we are talking about corporations, both for-profit and not-for-profit corporations, making expenditures in the political arena.
So
if they are giving to the candidate, then they've committed a crime.
I mean, is it worth thinking about corporations not as a monolithic category, but to kind of understand that there are differences among corporations, and maybe that should be relevant to how they're regulating the political system? I mean, you know, a corporation like the NRA or the ACLU gets its money from people who agree with its ideological message. A corporation like a public utility where you know, either you get your electricity from them or you don't, seems a little bit different. A publicly traded corporation seems different than a, you know, for-profit, non-profit. I mean, should that be the place that we look for regulation?
I think it's a logical thing to talk about, just assuming for the purpose of this argument that the various evils that the senator has identified are really there and need to be addressed in terms of public confidence. One of the very intriguing things in the record of that case, in the McCain-Feingold case, was the fact that an enormous amount of activity was in fact coming out of the nonprofit world. Right? So this is not Exxon and BP. So what do we do about them? And then to me, one of the most poignant and to me persuasive dimensions of this as I was getting into the case was the ACLU setting forth an ad that they had taken out during Mr. Nixon's presidency. And they said, if we had taken out that ad and it was contending that President Nixon in a particular dimension was violating American law, et cetera, if that ad had run within 30 days or 60 days, the windows created by McCain-Feingold, then the ACLU would have committed a crime. They said that just cannot be in a democratic society that values and treasures freedom of speech. So this is one of the reasons I think that the House was really divided because of the particular law's vast umbrella that brought in everyone. I'm not saying there would have been agreement if it had just been limited to for-profits, but a substantial part of the complainants in the case were nonprofit corporations.
Well, and this leads me to ask you about the Supreme Court's, the way the Supreme Court handled the case, which is...
Which case? The
McConnell the Citizens United case, because it would have been available to the Supreme Court, I take it, to say that the particular ad at issue wasn't even an ad in Citizens United. Citizens United is a small, very conservative ideological group that wanted to show a movie, Hillary, the movie, which was not flattering to Hillary, the candidate.
Surprise.
And they wanted to show it on pay for demand.
Yeah.
So you would have to pay for it, and then it would be beamed to you. And they challenged the Bipartisan Campaign Finance Act on the grounds that it made it impossible for them to show this movie because they had received corporate contributions that they were using to make the movie and to promulgate it. Now, I take it, perhaps you wouldn't have had a problem if the Supreme Court had said, the act doesn't cover that at all.
Well, it's more than that. I wrote it.
Yes,
I know that it wasn't supposed to cover that.
Right, but
so
by
the
its
United
literal
States,
terms, it
the
might
United
have,
States,
right?
sure, but clearly the United States Supreme Court has some responsibility not to go, well, we're not absolutely sure whether this was covered by the law or not. So what we're going to do is take a law from 1907 that basically no one has ever questioned, overturn it, completely change the political system of the United States of America, rather than leaning in favor of simply saying this wasn't covered by the statute. So this is why I say things about this decision that I'd rather never say about the Supreme Court. It appeared to be engineering a much broader agenda. The court clearly should have done that. In fact, if you want to read, and I have a lot of regard for Chief Justice Roberts as a legal mind, I voted for him. A lot of people were upset with me for that. I thought what he did on the health care bill was very interesting. But if you want to read a convoluted opinion, read his concurrence in Citizens United, which is one of the weakest, most defensive attempts to pretend that he was following precedent, following the canons of stare decisis, and the need to try to come with a limited decision rather than striking down a law of the United States. Because this, in my view, violated almost every canon of what the Supreme Court should do, apart from the merits of the issue. So, of course, Professor, they should have simply said, it was not intended to cover this movie about Hillary Clinton, and it wasn't. That would have moved on to the next case and legitimate questions that the judges raised about nonprofits. You should know that my goal was to ban soft money to the political parties. The provisions that had to do with the ad 60 days before the election, to be very frank with you, were added by Senators Snowe and Jeffords. We needed their votes. I believe that this was on balance constitutional, but I was more squeamish about it for the reasons the judges indicated. We made sure that the law was severable, meaning that the court could strike down that piece without striking down the ban on party money to the parties. But the fact is that there was simply no reason for the court to take this step. And I've heard a number of law professors, very distinguished ones, refer to as one of the worst decisions in the history of the Supreme Court. And it's in part for these reasons rather than the policy problem.
So one of the things is we've gotten several questions from members of the audience that ask essentially whether we shouldn't be regulating corporations, not by regulating the speech directly, but by, for example, requiring that the shareholders of the corporation approve the speech, or requiring that the corporation identify all of its spending on politics as a solution. Do you think it's a solution? And if you think it's a solution, do you think it's one that is vulnerable to attack on legal grounds?
Well, most of corporate law, of course, is governed by the states, but when we're talking about some particular activity in terms of your involvement in federal elections, I think Congress has very far-reaching power under the Commerce Clause and under the Necessary and Proper Clause to regulate in this area. In terms of corporate governance principles, I would just say as a matter of principle that shareholder authority is, I think, underutilized, and here we may find ourselves in agreement that boards of directors, all too frequently, are not genuine checks on management. And I say that as someone who now reports to a board of regents, who very adequately check management in my nonprofit world doing what they're supposed to do. But we've seen so many issues with respect to corporate compensation. And then what was the board doing? Was the board really on the watch with respect to that? So I would say have a great conversation. The First Amendment's going to protect it, and Congress will have tremendous power to regulate the way in which corporations, which are legal entities, the way in which they participate in the political process. But that having been said, if you say, and this is what you haven't said, that corporations cannot speak during this window, and this is where I do have to disagree with the senator, whom I admire, but I disagree with him on this. The Tillman Act and all these other regulations along the way said, thou shalt not, corporations, contribute to a candidate. But it was not the case that corporations historically could not speak into an election. And this is where McCain-Feingold created new ground by saying we're going to create a concept called electioneering communications. And so it has its own definition, but it really boils to you are becoming a participant in the election process during these two windows, 30 days and 60 days. So the very ad that I tried to describe in the Michigan Chamber of Commerce case, had that been on television, by the way, there's a definition there in terms of how far-reaching the McCain-Feingold Act was. It would permit, by the way, corporations to, if they saw fit, to take out ads in the newspaper. It was limited to, I think, these attack ads, electioneering
so-called phony issue ads.
The phony issue ads. And I will accept that. It was essentially a way of being involved in the conversation without using magic words of saying, I hereby endorse Senator Feingold or Senator Feingold's opponent. But I think there are ways that Congress could regulate in this area.
And this is an area of agreement. I do think that the decision has to be overturned. I do think you need disclosure laws at the federal and state level. But what you've said about corporate responsibility and the opportunity to affect this issue through the corporate form are substantial. There's a lot of initiatives at the state level about changing corporate law, changing how boards of directors are constituted, making sure there's citizen and community representation on boards. And I just saw a study that overall at corporations now, by far, the greatest number of shareholder resolutions have now surpassed climate change, environment, and other things. Number one is campaign finance. And here's what I'm also hearing from the leaders of the corporations themselves, because I've had an opportunity to speak at the Kellogg School of Business and a few other forums. I'm just saying, how do you feel about being the new fall guys of American politics? Because it's not that all corporations want to do this. Most of them don't. Most of them are horrified that they can get a call now for $10 million, and what happens if their competitor's doing it? Fred Smith from FedEx once came to me when we were trying to ban soft money. You know, he was a genius who invented FedEx, and you know, I was beating away on them for their contributions, and he came and he said, look, buddy, you set up the system. I didn't. UPS is going to give money. I'm going to give money. I have a responsibility to my corporation to not let myself be taken to the cleaners at the Congress. That's corruption, Professor.
Yeah, well, that's extortion.
Yeah, and so this is what we've done to the wealthy and the corporate interests in our country. The rest of us, our vote might not mean as much as it used to, and that's pretty bad. But they are actually subjected to what is basically looks to me like a system of organized crime. And even though it's technically legal. So all of this activity can occur outside of the law or outside of changing federal law, and I think it should be a big part of the effort to reform this.
Yeah, so a number of the questions that we've gotten are questions that focus on either changes in technology, that is, how campaigns are run, how they do get out the vote, or changes in the technology of financing the campaign. So to go back to something you said earlier, Senator, about, you know, raising money on the internet, or like where the marginal cost of the ask is zero. Do you think that some of the problems in the existing system are going to be solved, or at least are going to shift form because the technology for, you know, the imperative of broadcast television and the cost of the ads on broadcast television will go away as other forms of communication are the main way people get their news and hear the campaigns? Or conversely, that raising the money in small donations becomes more possible, and therefore the role of the large gift changes? I mean, are some of the problems we're seeing now just that we're in some kind of technological shift?
Well,
that is, the reform will happen as a result of technology rather than legislation?
Well, I mentioned the Obama campaign in 2008, which may be a game changer, and it may be a harbinger of things to come in the 21st century. And when we think about those, many in this audience and obviously on this campus, who have in fact grown up with technology, politics is going to be done in a very different way in the 21st century. It already is being done in a very different way. It appears that it is easier for insurgent activity to arise now than it was a generation ago. But our politics are so dynamic, and I must say, as I hear the senator, I just want to add this. Our politics has been so dynamic, certainly during my lifetime. I remember an insurgent campaign called Jimmy Carter. The establishment wasn't in favor of Jimmy Carter getting the nomination. Barack Obama himself ran an insurgent campaign. The party establishment was not in favor of him. The big money was not in favor of him. Senator McCain was the insurgent maverick, and yet he won. The Tea Party movement, whether you like it or hate it, the Tea Party movement is essentially this insurgent movement that saw great power in 2010. Perhaps it's waning, perhaps it's not. And how did that come to be? It came to be because truly of what Robert Kennedy called participatory democracy. People being, rightly or wrongly, very upset about the direction of government and then coming together in common cause. This is exactly what happened, and I'm old enough to remember this very vividly, in 1968, when a very distinguished senator from Minnesota ran an insurgent campaign for the Democratic nomination against President Johnson. Now, he didn't win, I mean, New Hampshire and so forth, but what was proven then, before the age of the internet, was that American politics, in no small part, are responsive to the felt necessities of the time. And that there is and always has been a very active grassroots, call it the progressive movement, that was so powerful right here. In fact, one of the reasons that we have, as you know, everyone in this room does know, whether you're a lawyer or not, the reason we have initiatives and referenda in the state is because of the power of a corporation, the Southern Pacific Company and so forth. So we now need to have a new way of governing ourselves. That was a grassroots movement. And so my point is, if you do have what the senator sees, this aggregation of corporate power, the other dimension, the other reality of American politics, which has been true for decades, is the people will, in fact, rise up, and they will find some way to change, including the system itself, rightly or wrongly, the initiative referendum system. We can argue about that in California. I lived here for a number of years as to whether that's wise governance. But the point is, we continue to have it, and we want it. Not every state has that. So my fundamental point is, just as the Tea Party movement arose out of, where did this come from? It was dismissed. Who are these cranks? And then, who does this senator from Illinois think he is? Well, he organized. He organized, and how did they organize? They organized using the tools of the 21st century.
I'd like to key off that, if I could, Professor. Yeah, the people will rise up, and they'll resist this, and they'll change things, and that's what the country did in the Tillman Act. So the Supreme Court decides you shouldn't have it that way. I mean, this is what happens when the Supreme Court is willing to...
The strongest example is the people of Montana rose up and banned corporate
They didn't want
contributions, and the Supreme Court struck down
They didn't want the copper
law.
corporations to dominate their lives. That was the law for 100 years. The Supreme Court has taken that away. I'm struck by your mention of Eugene McCarthy, I believe is what you were referring to, the senator from Minnesota, 1968.
Oh, yes, I'm not talking about the other McCarthy from...
No, Eugene, I know the difference. I was once the junior senator from Wisconsin, so we're not talking about Joe McCarthy. Well, I once went to a reception to honor Eugene McCarthy. I think it was his 80th birthday. Great admirer of his. He said the three worst things he'd seen in his lifetime were Hitler, Stalin, and the McCain-Feingold bill. I don't think he knew I was in there, but it was along these lines, because he said, you know, when I ran my campaign, I found 3 guys in New York, each of them gave me $80,000. So you can say that, and you can certainly argue that sometimes it can work toward a positive change, but we don't know that that's the case in the post-Citizens United world. What we have in the post-Citizens United world is a world that Eugene McCarthy never faced. And even Barack Obama never faced it as a new candidate. And that is unlimited secret contributions. That is a sea change. But I agree with you, even in the worst of times, even the worst of conditions, sometimes people can overcome this. But we've set the bar so high to overcome the crushing influence of that much speech. I agree with you that there's not, the problem in our society is not too much speech. people say to me, there's too many ads, there's too much. That's not the problem. The problem is when certain groups are able to dominate it in a way that is, I think, crushes dissent.
So Bruce Kane is fond of saying that 51% of the votes beats an infinite amount of money every time. And one of the questions I have, just to ask you both, is if people think that the system is corrupt, why doesn't their voting behavior reflect that? That is, how is it that the money leads people to vote for candidates who are not going to be responsive to the needs of the 51% of the voters in their districts?
I bet if you asked someone who voted for President Obama, do you think President Obama is corrupt? They'd punch you in the mouth. If you voted for if you're talking to someone who voted for Senator McCain, do you think he's corrupt? You'd likewise get punched in the mouth. You don't think your candidate, I'll bet you a nickel, is corrupt at all. You may have reservations about the system and the cynicism, but the good news is, and I understand what the senator has said with respect to one vote short and so forth. Maybe we can talk about the filibuster, because I have some views on the filibuster, because the filibuster, I think, is a very anti-constitutional rule. Some of my friends here will string me up afterwards, but I've long felt that the Senate filibuster is a profound mistake. It's not part of the Constitution, and it's anti-constitutional. I'm not saying it's unconstitutional. It's anti-constitutional in that the Constitution speaks in terms of majorities, and then it knows very well, it being the text, when you need to ratchet up and have a supermajority requirement. Now, this was a gimmick. Maybe it was an important gimmick from years ago. The senator knows much more about this than I do. But I think what we heard just a little bit ago is that the Senate would have passed something we both agree on, of disclosure. Let's have transparency. Let's, Brandeis, sunshine is the great disinfectant. But why didn't it pass in the Senate? I'll leave the House aside. Let's just stick with the Senate. Because you had 59 votes and not 60 votes. 51 votes should do it in any kind of democratic system. We look to the majority to determine it, and that's one of the beauties of our system. The 49%, or perhaps 50% plus one voted. You accept the results of that. That's just the way that it is.
So a number of the questions from the audience seem to go in this direction by suggesting maybe, at least until you have a different Supreme Court at the very least, you need to give up on campaign finance as the major source of political reform and look at, some of the questioners ask about the filibuster, some of them ask about gerrymandering, some of them ask about committee systems, some of them ask at the state level about whether term limits have caused some of the problems. So should we be thinking about a different kind of political reform because the current Supreme Court is just not going to let you do the kind of campaign finance reform that you might want to do? I mean, if you were coming up with a list of political reforms that you think you could get past the Supreme Court, what would they be?
Well, first of all, you don't give up on the campaign finance reform. Obviously, you don't just try to overturn the decision. You pass a disclosure law in Washington. You pass a disclosure law in California. You get rid of the Federal Elections Commission, which is a farce. It's deadlocked, it doesn't do its job, and you create a real enforcement agency. You take the social welfare provisions of the 501c4s, which are abused and are used as a pretense, but are actually used for political ads, and you tighten the definition. You tighten the definition of what's truly independent. When a senator sends the former chief of staff and legislative director over to create a super PAC, that language can be tightened. So there is a huge agenda, and as well as the corporate things we've talked about. But having said that, there are broader reforms, and in the filibuster area, because I know the judge wants to get into this anyway, so we might as well. I taught a course here about the Senate, and my view is that the filibuster still has a role, but there are aspects of it that clearly should be changed. And it was very sad to see, even though we had a Democrat majority, that there weren't 51 Democrats in favor of at least getting rid of the phony silent filibuster. Now, the silent filibuster didn't exist until 1975, when Majority Leader Mike Mansfield noticed some filibusters, and he thought, okay, we'll filibuster in the morning, but we'll do other stuff in the afternoon. It was well-intentioned. It's called a dual track. But what happened was people started saying, if you do this, I'm going to filibuster it. So what happened was they created the silent filibuster, the opposite of Mr. Smith goes to Washington. And what Jeff Merkley and others were trying to do was saying, if you want to filibuster, you should have to talk. And I always thought that was part of it too. So I think would be a reasonable step without eliminating what I still think has merit. The notion of the Senate as the cooling saucer of our republic, that when things fly through the House, and they do, Judge, constitutional amendments, it might not be such a good idea. It's a good idea to have a body that's a little more, in theory, deliberate. So it's supposed to be a cooling saucer, but as one of my students at Marquette said, it's not supposed to be a deep freezer. and that's what it's become because it's been abused. But I would agree to some of those changes.
I mean, what would you do about the filibuster? Just eliminate it
Well,
totally?
I would just get rid of it and just say, for reasons that I tried to say earlier, it's anti-constitutional. I fully agree that the world's greatest deliberative body, and I say that with respect, is meant to be deliberative. But the structural protection there is we don't elect all the senators at one time. And when you were elected and reelected, you knew that you were in for 6 years. And tempers cool and so forth. So we were talking about the flag burning statute. And then when I lost the flag burning case, 5-4, and we knew that we were going to lose it, the senator had to face the possibility of a constitutional amendment. Well, there are a lot of us who think the Constitution is nigh unto sacred, and you don't amend it just because you feel perhaps fervently about a particular kind of issue. That this too shall pass, and the Republic will be just fine, even if people, in the exercise of their First Amendment rights, their free speech rights, their symbolic speech rights, are burning the flag or otherwise engaging in this kind of communication. You don't like it, but one of the messages that I think is being somewhat lost in the debate, and I think it was to some of us on the outside, and we weren't subjected to electioneering ads, and I know how horrible they are. I've watched a lot of them. They're very ugly. They're very nasty. But in New York Times versus Sullivan, one of the great things that Justice Brennan wrote for the court is that freedom of speech frequently needs to be robust and uninhibited. Pretty strong language. That's what our Constitution protects. And then he goes into the next sentence and said, and frequently that speech will make us uncomfortable. I think Justice Brennan and Justice Marshall and the others saw that there's going to be speech that you really don't like, and you don't like it a lot. But the answer is more speech or ignore that speech, but not let's find a way to stop that speech based upon the identity of the speaker. And that's really the great divide here, the great policy divide, which I've tried to summarize as the forces of freedom and the forces of equality. Now, the final thing I want to say on this is the forces of freedom, beginning in Buckley versus Vallejo, say, okay, contribution limits because of corruption and the appearance of corruption. But when it comes to expenditure limits, on that court, only Justice Byron White, a great man and a great justice, agreed that the expenditure limits in the original federal election campaign amendments were constitutional. Since that time, grand total, 22 justices have served. Only one of the justices, including Ruth Bader Ginsburg, Stephen Breyer, good Stanford person, agree that expenditures can be limited. And that is John Paul Stevens, who recently left the court. And he came to that view, I think, whether it's the voice of experience or whatever. And so I would hope that there could be common ground on that. If you've got 8-1, and now I think it's 9-0. We don't know about Elena Kagan and Sonia Sotomayor. But if there is something that is established by precedent in terms of stare decisis, as we say in constitutional law, it is this: Congress and state legislatures don't try to limit expenditures by campaigns. Now, once you cross that bridge constitutionally, then huge issues open up in terms of campaign finance, don't they? Just think about it. The campaign can spend anything. So that means if I am a billionaire, I can spend whatever I want. And you know, that strikes a lot of us. That doesn't seem fair. Shouldn't we do something about that? And the Supreme Court is that's not 8-1 or 9-0. That was 5-4, the so-called Millionaires Amendment. But the point that I'm seeking to leave with you is anytime one tries to limit the quantity of speech by including a corporation, one is tugging at First Amendment values that I think now all 9 members of the Supreme Court would say, be careful.
Why is the Supreme Court prepared? They did not take the case that banned foreign corporations from spending money in American elections, which suggests they don't have the complete courage of their conviction that the source of spending means nothing. Because if a corporation can spend money, it's not clear why an American-owned corporation can spend money in the system, but a foreign-owned corporation can't. And I think their intuition is those foreign corporations are not really part of the polity. But if that's so, what do we do about the fact that an awful lot of American corporations now are multinational corporations with lots of foreign shareholders?
This is why the very eloquently stated distinction between freedom and equality by Judge Starr begs the question. The question is whether the corporate form should be the speaker. So, you know, let's say we can debate, and I think we'd have an interesting maybe debate, maybe just discussion about what individuals can do. Again, this is the corporate form. This is a limited liability entity created by the state. The government creates corporations, doesn't create people. They could be eliminated. If corporations have these rights, why can't they vote? Some guy in Maryland wanted to have his McDonald's run for office. The other day, another guy got pulled over in the HOV lane. He was by himself. Did you hear about this one? So this is actually happened. He got pulled over, and he was supposed to have somebody else in the car, right? He said, wait a minute. He had some corporate incorporation papers. There's another person in the car. So, you know, don't get me wrong on this. This isn't about disdaining corporations generally. I believe in corporations. I went on Stephen Colbert, which is often a mistake, but, you know, he gets on before and says, you know, Russ, this is going to be fun. I'm an idiot, and you're going to correct me. And I thought, okay, this sounds good. So the lights come up, and he says, today we have recently deposed United States Senator Russ Feingold. And he comes right at me, and he goes, he says, Feingold, what have you got against corporations? What's your problem? When you see a corporation walking down the street, do you cross the street? Would you let your daughter date a corporation? You know, so the problem here isn't a disdain for corporations. It's whether they should be on this side of speech that he's talked about and of freedom, given the advantages and the artificiality of how they were created. I think that's really the response to obviously a legitimate distinction that the judges made.
I often wonder, though, if people, because of the salience of Citizens United, people have focused a distrust or a fear on corporate speech that really isn't about corporate speech. It's about vast aggregations of wealth more generally in the United States and the threat that vast aggregations of wealth in individuals pose to the political process. I mean, if we think about what was the most distortive aspect of the 2012 presidential race, it was the ability of a couple of billionaires to keep the Republican primaries going on far longer than they otherwise would have, to, as a result, force the candidate who ultimately got nominated by the Republican Party to run to his right in the primaries, making it harder for him to tack back towards the center in the general election. And I wonder whether that kind of distortion is something that's just incurable if you're going to take the kind of strong version of the freedom argument or the liberty argument.
In my view, it's incurable. Is it bad for the system? Perhaps it is in a particular election cycle. It certainly was absolutely horrible for Governor Romney to have this happen. The answer is more speech. And I know that sounds hollow, but that is our system. Because when you then start to say, okay, how will we regulate that? All right. Sheldon Adelson, you have given Newt, and by the way, we know what he's giving, don't we? So there is
well, it took a while to figure out what it was because not all of it had to be disclosed. I mean, if he hadn't wanted to disclose, I mean, you know, you've got somebody who wants everybody to know he's spending $10 million.
Everybody just kept going to Las Vegas. It became sort of obvious that what was going on.
Let us stipulate that disclosure is good and that I am in favor of disclosure. So we know that Sheldon Adelson, and let's say we have a disclosure model, is giving all this money. The idea is we get to assess this. This is First Amendment doctrine that you learn as a baby in law school. We don't want the government doing the evaluation for us and saying, Sheldon Adelson, you have spoken enough, please sit down. Sheldon gets to talk as much as he wants to talk, and then we don't have to listen. Or if we say, well, it's Sheldon Adelson doing the talking, then I don't agree with what he says, and therefore I'm going to support someone else. That's the nature of our system. We do not want government in the business of doing this kind of regulation substantively of who gets to speak, and that is also where the great divide is with respect to corporations. The senator rightly says corporations enjoy the corporate form and limited liability, and there's no question. Those are pretty special. At the same time, it is settled law, and I mean it is settled, that corporations do have a number of constitutional rights. Not all, but they do have a number of constitutional rights. And one of those constitutional rights is because of the nature of what Thomas Emerson of Yale, a really great man, called our system of free expression. And that's what Tony Kennedy has really bought into. It is far better for us just to put up with this cacophony of voices, these loud voices, than it is to try to regulate those voices.
Does it trouble you that the Supreme Court has made it much more difficult for public financing, for effective public financing of elections to exist? That is, if people say, I mean, the obvious case to think about here is the Arizona free elections PAC case, which is Arizona wanted to have a public financing system so that candidates could run without having to be beholden to large donations or lots of spending. But they said the way we're going to run this system is if your opponent doesn't take public financing and you do, we're going to give you extra money as your opponent raises more money so that you can continue to speak. And the Supreme Court treated that as if it were a restriction of the speech of the candidate who wasn't participating in the system. Do you think that's right, to treat that as a restriction on speech?
I think that's arguable. I think that you make a reasonable critique of it. It may be a misapplication of the principles. I'm not going to say that it is. I have not studied it closely enough as you have to say that it is a misapplication. But any principle can be misapplied. There's no question. You can be too rigid in the application. And I know that there are people in this room, perhaps many people in this room, who just say, we love Tony Kennedy, but we just think he's wrong about this. But I would just ask you, before you conclude that I disagree with Anthony Kennedy, the leading First Amendment protector on the Supreme Court of the United States, I would ask you, read his dissent in Austin versus Michigan Chamber of Commerce, read that ad, and then just say it's all right for the Michigan legislature to make that ad, that newspaper ad, a crime. That was the decision that was specifically and expressly overruled in Citizens United.
Well, I think it was a very unfortunate decision, the Arizona decision, the other ones that try to inhibit public financing. If the proposition is there should be more speech, how does it hurt the millionaire that somebody gets a little more money from the government so he can have a little more speech? It's more speech. It's not less speech. So how does this inhibit anyone? He can spend all he wants. And yes, the other person is going to get some help, and I assure you, given the paucity of money in these public financing funds, it's not like the person's going to catch up. They're just going to have a fighting chance. And so I think that's a really very unfortunate crushing of what you talked about, which was a state-by-state experimentation. Arizona, Maine, they went with voluntary public financing years ago, and it was a great success. People like police officers and teachers and others were able to run for office who couldn't in the past. This was a good state-by-state initiative. I happen to believe we should have public financing of a similar kind for congressional and Senate races, which we've never had, and fix the presidential system. But I think it's very unfortunate that the court is trying to diminish that on the ground that somehow it diminishes the speech of the millionaire.
Well, there is an irony, and again, you're seeing I'm not pushing back on this particular account. Because of the laboratory of the states, and one of the things I think it is wise for us to do when we're thinking about campaign finance reform is look at what the states are doing. And in fact, a number of the states, I think, Senator, 20-plus states have some form of public financing. Whether you think that's a good model worthy of study And ordinarily, the Supreme Court is going to allow these kinds of experiments to go on, but here it did not. Now, that doesn't say that all public financing regimes in the various states have been invalidated, not at all. But I do think that as a general matter, the Supreme Court will be fairly solicitous in saying, let's allow these different states to experiment, call it federalism kinds of values, which is one of the forms of liberty that, again, Justice Kennedy feels very strongly about. If you familiarize yourself with his work over his 20 years, he is very protective of our federal system, call it the rights of the states, and he's very protective of our system of free expression.
If you could propose one law one campaign finance reform, or one political reform more generally, what would it be?
I would go in favor of the Virginia model that I, as it were, grew up with as a citizen, and that is no limits. Source, corporations, unions, Sheldon Adelson, give all that you want, no limits on source, no limits on the amount, and instant disclosure. And I tell you, it works in Virginia. It works in Oregon. So those are two pretty good states, and I think there are other states. But the move has not been in that direction for whatever reason. It's not as if Virginia just did this day before yesterday. I've been living there since I was 25 or 26 years old, and that's been the system. And it's a very vibrant system in terms of the politics, and I'm talking about the state politics. Obviously it's voted for President Obama in the last two elections. Ordinarily it votes for a Republican, but now we're talking about the state system. And in the Commonwealth of Virginia, Democrats are elected governor, Republicans are elected governor. It is a very competitive system, and it is quite well known to be an honest system, a very honest regime. And I don't want to make any invidious comparisons, but Maryland across the way has a very restrictive set of campaign finance regulations, so they're very pro, let's regulate, regulate, regulate. And I would just say, I, as a Virginian for many years, will proudly put up the record of good government in Virginia up against the great state of Maryland.
I take it that would
I don't have a dog in that.
That wouldn't be your reform. That wouldn't be your reform.
No, it wouldn't do the opposite of it. But I would have a voluntary public financing for all campaigns. A system that is properly funded, to give people who, apart from all these other issues, whether Citizens United is overturned, which I think it will be, and other reforms that I've suggested, is having a public financing system where a candidate can say, I'm going to agree to spend no more than a certain amount, get some help from the government. I mean, I wouldn't have had the wonderful career I've had it not been for many decades ago. Wisconsin had a system that worked. And so when I came out of law school, practiced law for a number of years, and I wanted to run for the state senate. The law at that time said, if you agreed to spend no more than $35,000, which I couldn't even imagine that kind of money anyway, if you raise half of that, $17,500 in contributions of $100 or less, then the state would give you a check for the other amount. And so I looked up every remote cousin I'd ever known or friend from high school and got $10. And by the way, people I didn't know, were apparently my cousin showed up when I won for the U.S. Senate. They came to the party. But so a person who had no money, 29 years old, coming out of a couple of years of law practice, I was able to run a grassroots campaign. I got elected by 31 votes out of 47,000.
Wow.
And my opponent, who was 83 in a very Republican district, didn't campaign very hard. He figured a guy that had a lot of hair and in the rural area, so I might not do so well. He didn't take the public financing, but he spent somewhat more than I did. This was the only way that somebody like me could run. And to me, allowing that kind of a system to be part of the system at all levels, including, of course, and I agree with you, very unfortunate that President Obama became the first person to not take public financing. That led to the disaster that we have now, that a system that actually worked. When Reagan beat Carter, they had the same money. When Carter beat Ford, they had the same money. It was a public grant. And I didn't hear people on the right or left saying there was really anything wrong with that. That system needs to be repaired as well, but it would be along those lines.
Yeah, I mean, I sometimes think we get the elections we're willing to pay for as a society in two different ways, right? One is we don't pay to have the elections run properly by professional, nonpartisan election officials. We rely on volunteers often to run them who are older than
very nice
their opponent.
people, very good
nice
people,
but not always fluent with the computers, right? I mean, the Maryland disaster where they didn't send the smart cards to the polls and the same thing is true of our campaign finance system. I mean, if every American who voted contributed $25 in campaign contributions, that would dwarf the private money that's now in the system. But of course, if you're going to rely on running elections on the cheap, you may get the elections that you're willing in that sense to pay for, and the candidates that you're willing in that sense to pay for. The people who are willing to pay for candidates do get candidates.
I couldn't agree more.
Well, I also think, even though this is a narrow point, I think it's very important in terms of the cynicism that the public has and the polls you saw in the New York Times yesterday. The Kennedy School Institute of Politics has just come out with its spring 2013 poll of the views of millennials. So these are 30 years and under, basically, folks in their 20s. And so there is this rising tide of cynicism, which is very, very, very troubling. I would say that one dimension of the problem of cynicism is the odd, and I really don't understand it, ignorance of Americans with respect to their system. I mean, we're talking at a fairly high level here in this conversation, and yet the polls show that Americans, not those in this room, tend not to pass the naturalization exam. We have a very high flunk rate. So if you just go out and Gallup, whomever, gives the naturalization test to Americans, we flunk. Then you'd say, wow, it must be a really hard test. No, well over 90% of citizens undergoing naturalization pass. It's not that hard. Everyone here would probably score 100 or pretty close to 100. So it's one of the reasons that Justice O'Connor, Stanford alum, Justice O'Connor was so concerned 10 years ago, 12 years ago, with respect to judicial independence and what she saw as threats to judicial independence. And she began talking about judicial independence, and she saw, in her words, people didn't know what I was talking about.
Yeah.
They had no clue what I was talking about. And so she dialed back, scrolled back, and Stephen Breyer's involved in this effort, David Souter's involved in this effort, and what it is, it's we need to be civically educated. So I have a feeling that if our people knew more about the system and were therefore involved in the system, perhaps this degree of cynicism, it wouldn't correct the concern that Senator Feingold has. But I think some of this sense of cynicism and disattachment really has to do with the apparently profound ignorance that infects the American polity and the collapse of civic education in the United States. I'd also say very narrowly, I think judicial elections, partisan judicial elections, are absolutely anathema. And I think that is very corrosive of the public trust in honest government.
I think the
last words.
Well, I just wanted to have perhaps a third area of agreement about civic knowledge. And first, I want to thank you for mentioning the Stanford graduate who voted to uphold McCain. I respect Justice Kennedy as well, but a little balance there. I do feel that there's been a substantial decline in the awareness among people coming out of high school or college in the basic structure of the Constitution, as you say, notions of judicial independence. The system is not inculcating that with people in a way that I felt was drilled into me. I mean, as early in the public schools, 7th and 8th grade, we were required to learn the Bill of Rights and the Constitution, and of course it wasn't a real high level, but it was enough so that I had a concept of it, got more of it in high school, got more of it in undergrad, got more of it, but it was a part of my life from a young age, and that was across the board. I can't say that it isn't done now, but I should be more knowledgeable about exactly what's taught, but there is this sense that people don't have a sense of exactly what this social contract was all about and is all about. And I think that's disturbing.
So maybe we can agree as a matter of common ground that we ought to have a no citizen left behind bill to replace no child left behind. I want to thank you all very much for coming. I think I got to ask an awful lot of the questions. Some of the questions I couldn't ask because I couldn't read them, and some of them I couldn't ask because I didn't want to. But I did ask a lot of the questions, and I hope that you got a lot of the answers. So thank you all very much for coming.
Really great.
Oh, you were wonderful. It was fun. We did find common ground.
Yeah, and I'm glad you, Justice O'Connor, that was good. Yeah. I kind of report to her. Exactly.